Good afternoon. My name is Paul Millenbach. I'm a shareholder at Foster Swift Collins and Smith in the Southfield office. And with me today is my partner, Dora Brantley. Dora Brantley is in the litigation practice group at the firm, is a fairly recent hire to the firm, a recent addition to the firm. Very happy to have her here. And Dora is going to speak today on premises liability. Dora, could you please introduce yourself?
Yes, thanks, Paul. Thanks for having me. As indicated, I am fairly new to the firm at Foster Swift. I joined Foster Swift back on June 1 of last year. But I've been a litigator since 1993. So what is that, 31 years at this point in time. I have primarily, over the years, my practice has waxed and waned as it relates to the types of matters I handle. I started off in the professional liability world, representing doctors and other medical professionals, and that then shifted to doing quite a bit of real estate litigation type work. And then from there, I went to a lot of personal injury type work, which is what I primarily do right now. A lot of slips, trips, falls, some third party auto negligence, some hot beverage burn cases. I do some civil rights litigation, also some employment litigation. Sometimes I feel like I'm all over the place with respect to my practice area. But that's it in a nutshell.
What courts do you practice in?
Oh, I have practiced all across the state of Michigan. I have been as far up as Marquette, and I have been in Monroe County. I've been in St. Clair County. I wish I could say that I was primarily in the Tri-County area, but that is not the case. I am really all over the state, in the state courts. I am also admitted to practice in the Eastern District of Michigan, Western and Southern divisions.
Well, today we're going to talk about premises liability, and that's been a kind of a hot topic over the last year or so. There's some changes that have occurred to premises liability. Can you describe what happened that resulted in these changes?
Absolutely. As you indicated, Paul, there has been a seismic shift in the landscape of premises liability. Back on July 28 of 2023 was when the decision came down in two consolidated cases, Kandil-Elsayed and Pinsky versus Kroger, and it transformed the premises liability world. The spotlight was placed directly on Michigan's open and obvious doctrine in these two cases. In Kandil-Elsayed, it was argued that the snow and ice, which covered a parking lot, the surface of a parking lot, was open and obvious, and because of that, the trial court dismissed that case, granting summary disposition to the defendant. In the Pinsky versus Kroger case, which was a consolidated case that went up to the Michigan Supreme Court, the trial court actually denied the plaintiff's motion for summary disposition. And in that case, there was a Kroger store where the plaintiff, she had gotten in line at the checkout lane. She realized the bag of flour that she had with her was open. She decided that she was going to go back for a new bag or a fresher bag. And as she did that, and she traversed down the aisle, which was next to the aisle she was in, I believe, she encountered, or she tripped over a rope, or essentially it was a rope that was blocking off that aisle from persons entering that lane. Again, the trial court said that is, or at least there's a question of fact whether or not that's open and obvious, and denied the defendant's motion for summary disposition. That went up to the Court of Appeals. The Court of Appeals reversed and said, no, that is open and obvious. And that just set up the perfect storm for both of those cases to go up to the Michigan Supreme Court. And the Supreme Court took quite a bit of time in deciding and finally issuing its opinion like I said, in July of 2023, abrogating the open and obvious defense in Michigan. Open and obvious is no longer a bar to a premises liability case. So it no longer goes to the issue of duty. It now goes to the issue of comparative negligence that attaches to a case. So again, a seismic shift, and I'm sure we're going to get into a little bit more of that as we move forward in this discussion.
Yes, thank you. Open and obvious, that's obviously a term of art. You and I use it on a regular basis. Before the Elsayed decision in 2023, could you tell us what open and obvious meant?
Sure.
What it was.
Yes. So open and obvious, it really means just that. Even though it's a term of art, I think that it's one that is easily understood by the general public, in that if a danger or a hazard is open, a reasonable person was able to visualize it. And it was obvious that it could in fact cause some type of harm, i.e. ice. If a person were to step on, attempt to walk across a sheet of ice or walk across a wet floor, or they're on a stage. There was a case which the plaintiff was on a stage. They did not have a barrier on the stage, and the plaintiff ended up tumbling off the edge of the stage. Those were all open, what we would consider open and obvious hazards. So a reasonable person would be able to see and appreciate the hazards. And again, under those circumstances, pre-Elsayed, the courts used that framework and said, if it's open and obvious, there is no duty owed by the owner of the land or the possessor of the land to the plaintiff or the person who was injured, and therefore the case was dismissed unless there were two exceptions only, and they were really limited. Those exceptions were if in fact a hazard was unavoidable, which was described in the leading case, which is Lugo, as a business which is open and it has only one ingress, egress. So one way in, one way out, and there was standing water at that door on the inside, and a person was essentially trapped inside. That is essentially unavoidable. Or the other exception was unreasonably dangerous. So, and the Lugo court described that as a 30-foot pit in the center of a parking lot. So again, just that, if someone were to encounter a 30-foot pit that's unguarded in the center of a parking lot and they fall in it, they're likely to suffer some very significant injury. So that was the other exception to the open and obvious rule.
And was, under the prior standard, what would happen with most cases that you defended?
Sure. If it even became a case, that was prior to July of 2023, or this new decision that's come down, I would talk to plenty of plaintiff attorneys, and they wouldn't even file the cases because they knew that they would likely be dismissed on summary judgment or summary disposition, where it was an argument that the hazard was open and obvious, and if the trial judge was in fact following the law, he or she would dismiss the case. And if the case did proceed, if the case was in fact filed, then just that, the defense would set it up from the beginning as, an attempt to develop that this was in fact an open and obvious hazard, and ultimately get to that point where he or she is filing that motion for summary disposition. And again, if the trial court is following the law, it is likely that that case is going to be dismissed.
And that was kind of the standard that was in effect prior to 2023 for how many years?
Lugo was decided in 2001. So that was, we had 22 years of the open and obvious world.
Right. And that was
a long time.
And obviously those that under that standard, that was favorable to business owners and insurance companies, but all of that is since changed in 2023. And you touched on it a little bit earlier, but what was the significance of the 2023 decisions that changed the open and obvious standard?
Sure. So by way of this Kandil-Elsayed decision, open and obvious no longer goes to the question of duty. So as an example, before July of 2023, this decision came down. If a hazard was open and obvious, there was no duty. The land possessor owed absolutely no duty to the person who was injured, except for in those two situations that we discussed earlier. Since Kandil has come down, open and obvious is still relevant, but it goes to the issue of damages, to comparative negligence. So it's no longer an issue that is decided by the judge. It should be decided by the jury.
Okay. And so in that case, when it's decided, if it's something that should be decided by the jury, according to the Supreme Court, what happens at the trial court level when obviously a defendant files a motion for summary disposition?
Well, I think we're going to see a lot fewer motions for summary disposition on the issue of open and obvious. What we have seen since the Kandil decision was decided was even those flurry of cases that were in the appellate courts pending on this issue, they actually sent all of those cases back, or most of those cases probably at this point in time, saying that this should now be evaluated in light of the Kandil-Elsayed decision, and this is a jury decision or a jury question and not a judge's decision. No longer the court.
All right. Are there any other than open and obvious defense that was utilized primarily before 2023? Are there any more defenses that are still available to a business owner or a property owner?
Absolutely. Absolutely. So notice is one that has absolutely not changed. And notice essentially says that the business owner or land possessor has to have actual or constructive notice of the hazard. I think that we're going to see a lot of motions for summary disposition on that issue, or at least the attorneys are going to try to set up their cases to establish that the landowner or land possessor did not have notice of this hazard. Actual notice would be either the landowner or the land possessor has created the hazard themselves, or they knew about it. And then there's constructive notice, which is the other one. Constructive notice would be evaluated if the hazard has existed for such a period of time that the landowner or land possessor should have had notice of the hazard. So that can get into a little bit of a slippery slope as well, but I think that everybody's going to be working with their attorneys to really develop those defenses. Notice, and I apologize, I got stuck on the notice issue. So the other defense would also be comparative negligence, which we talked about previously. That remains in play. And there is case law and statutory law, which indicates that if a plaintiff is determined to be more than 50% comparatively negligent, his or her non-economic damages are barred and their economic damages are reduced in accordance with their degree of comparative negligence. So that's still at play. And then there's also the issue of determining the status of the person who is allegedly injured, whether that be that person is a licensee, trespasser, or invitee, because a different standard is applied to all of those categories.
Okay, let me break that down a little bit. So there's three defenses that are still available, more or less, is the notice. And an example of that be if you own a store, you owned a hardware store, for example, and there was a bag of fertilizer that broken open and leaked fertilizer over the floor, and somebody comes along and slips and falls on it, that person still has to show that you knew or should have known that fertilizer had spilled. Is that correct?
That is accurate. That is accurate.
And then the second one, and I'm just going to the second one, the comparative negligence. Comparative negligence, you can still utilize open and obvious. This is where it's a little bit confusing. You can still use open and obvious defense to determine whether or not the plaintiff was comparatively negligent by not paying attention when they slipped and fell on that bag of fertilizer.
Absolutely. Yep. You got it.
And then the final one is what the class of the plaintiff is. Whether there's basically three classes. There's invitee, licensee, and a trespasser. And in terms of that gets into what you call duty. What's the highest duty that a property owner has of those three classifications?
Invitee. So an invitee is someone who the landowner or land possessor invites on their land for a commercial purpose. There has to be a commercial purpose that attaches to it. But the highest level of duty is owed to an invitee. So you think about a customer inside of your inside of your restaurant or your hardware store, those would be considered invitees. So there is in fact a duty to make the premises safe for those persons, and it requires the landowner to warn of dangers that they know or should have known about. They are required to inspect the premises, depending upon the circumstances, for potential hazards. So that is the highest duty of care.
And then the second would be licensee. What could you give an example of what a licensee would be as opposed to a customer of a store or a restaurant? What would a licensee be?
Sure. So a licensee is just that opposite, was not quite the opposite, but the person is on your land, permissive use, but not there for a commercial purpose. So there's case law which indicates that a member of a church is at service inside the building. That is a licensee. There's case law which indicates that someone, let's say an apartment building, a tenant of an apartment building invites a guest over. That guest is a licensee of the owner or possessor of the land, not necessarily of the tenant. So what happens inside of the tenant's apartment, the tenant may be liable, but perhaps something that occurs, i.e. the steps on the outside of the building, that would be a licensee under the current status of the law. They're invited onto the land, but there's not a commercial purpose that attaches to it. There's no benefit to the landowner or the land possessor for that guest to be on the land. Okay.
And then a trespasser, does the landowner have any duty at all to a trespasser?
Well, yes and no. Landowners have pretty much no duty to a trespasser, but you cannot engage in willful and wanton negligence. And essentially what the case law indicates is that willful and wanton negligence has to be active negligence on the part of the landowner or land possessor. So you can't actively create a situation that you know is going to injure somebody, and then somebody wanders over onto your land unbeknownst to you. So for the most part, there's no duty, but I think that you have to be a little bit careful in that classification, that there's no duty, because there is a slight duty. You can't do something to make your premises unsafe and then someone is injured. You might be found liable.
Is there anything that a business owner, a property owner, a homeowner, and I know you can't do everything, but what can they do to try to reduce the risk, to prevent liability for a slip and fall under the new regime, I guess?
This actually is a question that gets into risk management. There is really no case law which says do this, don't do that, don't do that. It really comes down to what would be considered reasonable. So that's what the jury will be assessing in the end, is what the landowner or property owner or possessor, what he or she did reasonable under the circumstances. But I think that if we're talking about just in a more general context, what can a person do? I think it really comes down to just being smart. Again, you do have to at least eyeball and look around for hazards. And if you find something, you actually have to correct that hazard. You've got to make sure that you're warning, i.e. if you mop the floor, a business owner, you mop the floor, that you put up wet floor signs to provide notice to somebody entering your establishment that there could be, in fact, a slip hazard. Again, I think it really just comes down to what's reasonable. What is a jury ultimately going to determine what is reasonable under the circumstances?
Right. Assuming somebody were to slip and fall or trip and fall on a premises, what should the property owner do? What type of action should they take?
Yeah, and again, this is, gets into risk management, but ultimately, From my perspective, and I, of course, I've always been on the defense side, and it does frustrate me sometimes when I receive a case and find out that, my client has really just kind of buried his or her head in the sand. But if you know that somebody was slipped and fell on your property, regardless of whether or not you know that that person was injured, you should be preparing an incident report. Even if the person says that they don't wish to prepare an incident report, prepare the incident report based on what it is that you know. And it could be that customer refused to give his or her name, but who were the witnesses to what happened? I think it is about documenting. I think that it's also a matter of, taking photographs of what caused the slip and fall, or the area where the person slipped and fell, because sometimes it's not something that's actually on the premises. It might be the person's shoes, or whether it be the sole of the shoes or something that the person tracked into your business establishment. There's a lot of different things that go into a slip and fall, but make sure you're taking photographs of the area where they fell, close in time to the actual fall, not 3 hours later. If there is video that covers that area, make sure you're pulling that video. And I like to pull the video for the entire time that the person is in the establishment. Some business owners will just pull the video that catches the slip and fall. I think it's very important from my perspective, to pull a video for the entire time the person is in the establishment. And it might be in different areas of the establishment. But pull all of that. And if the floor was recently mopped, you might even want to, or if there are wet floor signs down, might pull video, which even prior to the person entering your establishment, so you can establish when was the floor mopped in relationship to when the person came in and slipped and fell. So there are a myriad of things that should be doing, but I think that in the end, it just comes down to document. If you get witness statements, or even if you don't get witness statements, find out who was there. Make sure you're documenting their names, addresses, telephone numbers, so that if in fact this doesn't come into play later for litigation or a claim, that you're able to go back and contact those individuals and find out what it is they know and what it is that they're going to say as a witness in a deposition or a trial.
What about the final question? Then we'll take some questions from the chat. What about repairs to the property? Say, for example, somebody tripped on a uneven sidewalk walking into someone's home or business. Should the business owner repair that right away, or do they have to wait until the litigation ends or any specific period of time? And if they do repair it, does that kind of give the impression that they were guilty or liable?
Yeah, I hear that frequently, that well, if I repair, or if I apologize, then it makes me look like I'm guilty, or culpable or liable, and that's not in fact the case. One, I think that you should have to repair in order to avoid someone else from being injured in that same manner or on that same hazard. But before you repair, just make sure you document it by way of photographs and video if possible, what it is, what the hazard looked like. If it's an uneven sidewalk, you might even want to get a ruler out and take a photograph of the difference in elevation with the ruler to establish, this is a 1-inch difference in elevation, this is a 3-inch difference in elevation, and those could mean different things depending upon the defenses that are pursued in the case. But they're actually built right into our rules of evidence in Michigan, is a rule related to subsequent remedial measures. And subsequent remedial measures, and I think it's MRE 407, but subsequent remedial measures are not admissible to show that a hazard or a condition could have been made safer and prevented the situation from occurring. So you don't have to worry about it being admitted for that purpose. It can be admitted for other purposes, for purposes of, i.e. impeachment, or if the business owner were to say that, I don't own that, or I don't control that, and then you go out and repair it, that could be used as evidence that in fact you did own it or you did control that area. So, but for just the general purpose of saying that, of establishing culpability, it cannot be admitted for that.
Thank you. That was very helpful. I have a couple of questions in the chat. The first one, probably in the context of preventing liability is this like having to put a fence around a pool?
That is certainly one of the things that you should do, absolutely, because with pools, you're getting into what we call attractive nuisances in Michigan. So a child who wanders over onto your property and is injured in your pool, there might be some liability there because a pool would be considered an attractive nuisance. You should be making that pool safe by way of some type of barrier around it, which will prevent individuals from being injured.
Okay. And then another one is to align to the duty of notice regarding ice on a parking lot. In addition to treating the parking lot with salt, are we protected if we send out a communication to the employees that the parking lot might have ice?
Okay. I don't know. Well, no. Are
There's
you
a little employee element to it, which
right? Right. I think that's where I'm having the problem. Are you protected if here you're talking about an employee who is injured? Are you protected? So the employee, let's take that in two steps, because the employee would technically only have a workers' comp claim.
right.
Workers' comp is exclusive in Michigan. So if we take the employee aspect of it out, I think it'll be a little bit easier to answer for purposes of our discussion today. If you put out a notice and let's say, because you do go to some businesses and they have posted signs, parking lot could be slippery, or you see wet floor signs, are you protected? You're not insulated, no, but obviously providing some type of notice to that individual that a hazardous condition could exist. Those are all arguments that we ultimately we would use in the defense of the case. And as I'm thinking about that question, I think that might be conflating two issues: notice to the business owner, what we talked about earlier, notice to the business owner of a hazardous condition versus notice to the general public of a hazardous condition. So those are two different things. The notice to the business owner is what did the business owner know or should have known about the hazardous condition. Notice to the general public comes down to, it is helpful to provide notice. And actually, well, you do have to provide notice to an invitee. You have to provide notice of a hazardous condition under the law, under the standard. But you don't have, but again, that kind of go into what the evaluation of what is reasonable on the business owner's part.
Yeah, I think you made a good point about it doesn't entirely insulate you. For example, you were in your parking lot of your business, you were to put a sign up that says ice is slippery, be careful, and somebody slips on that ice, you're not completely abrogated of any liability if you didn't treat the ice, correct?
Correct. Absolutely. You still have to take reasonable steps to treat that ice.
And if you treated the ice, but you didn't do a good enough job, would you still have liability as well?
You do. And whether or not you treated the ice effectively, that comes down to a question of fact, really. In the end, I mean, ultimately, from the defense perspective, we will argue that we're in Michigan 1, snow and ice is a common occurrence, and we treated the parking lot and sidewalk with snow melt or ice melt or whatever it is. We even had a company come out, third-party company come out and do the same thing. But in the end, ultimately, that's all going to be a question of fact. I don't foresee a judge saying that, well, what the defendant did is good enough, because I think that at that point, the judge has been stepping into the shoes of the jury. And the jury gets to determine whether or not what the business owner did is reasonable or not reasonable under the circumstances.
Yeah, and I think that's kind of the point of the case, or the effect of the case, is that it's going to be a question of fact. That you're probably not going to get the case dismissed like you could for the last 22 years. And certainly then you have to, and then you think, okay, the judge isn't going to dismiss the case, but I'll prove it to a jury that we weren't negligent. What kind of problems or what kind of issues does that create for you as the business owner or the insurance company, taking that risk? Or that's just it. I probably answered my own question. So
right.
we have a couple more questions, and we're a little bit out of time. And that icy parking lot was a very good question. Has anything changed in terms of incidents at construction sites, i.e. duties owed to a subcontractor's employees on a job site, omitting the contractual piece? What is the duty owed to the subcontractor? Would they be considered an invitee?
Oh, I will have to punt on that question. I would not venture to answer that question in this context without doing a little bit of research. I know that the Elsayed case did not address that issue. But at that point, you're really getting into more so the intricacies of construction law and agency law. So I'm just not prepared to answer that.
Okay, fair enough. And I think the contract is pretty relevant in those types of situations as well. But we can certainly, Amanda, who posed the question, we can certainly follow up with you on that without a problem. The last question is, are you protected if someone slips and falls on the sidewalk? Is this considered city property? 2 questions. That's the first one.
Yep. So if someone were to slip and fall on your sidewalk, it's really going to depend on, I'm assuming this is a homeowner, or maybe not. So your land, what is considered your land in the end? And that's what it comes down to. Is your land, does it include the sidewalk? Is there some type of, when it's platted out, is the sidewalk considered your property? Is this drivewalk considered your property? I think under most circumstances, it probably is considered your property. I know that when, as an example, a business owner purchases or leases even a commercial building, typically the contract actually has an addendum which identifies what this business owner is leasing. So does it in fact include the sidewalk? Does it include a part of the parking lot? So I think that probably gets into more of a case-by-case basis on what is yours and what is not yours. Somebody has to own it, ultimately.
Yeah, I think you're right. I think if it's a case-by-case basis. My experience with that is that the extent of the ownership of the land. If it's a sidewalk in front of someone's home, it might be a municipal sidewalk. If it's a sidewalk in front of a downtown building, it might be a city sidewalk. It all depends.
I agree.
But the same standards of liability apply to either one, correct?
Yes, I agree.
The last question is, what if someone is intoxicated while getting injured?
So that if someone is intoxicated, it certainly does not relieve your duty for reasonable care. Ultimately, intoxication would go into the question of comparative negligence. And so again, there are arguments to be made. Mr. X was intoxicated and he tripped over the parking stop in my parking lot. No, that's probably a bad example. Mr. X was intoxicated and he stumbled off of a crumbling curb at my business. So are you, as the property owner or possessor, responsible for that crumbling curb? Yes. You're not responsible for the person that is intoxicated, and ultimately those two things have to mesh and a jury is going to determine, well, what really was in fact the cause of this person stumbling off the curb? Was it because the plaintiff is not going to concede that his or her intoxication is the reason that they stumbled? They're going to say that they stumbled because of the fact that the curb was deteriorated and crumbled underneath my feet. I've had that case, I think, several times. not the intoxication part, but the crumbled curb. So again, it's just gonna go back to the comparative negligence argument. You don't get off the hook just because somebody's intoxicated on your property. That's really the bottom line.
And it won't help to have a sign that say drunk people fall down.
That's not gonna go by there.
Okay, that's all the time we have. We're a little bit over, but certainly I appreciate your time, Dora, as well as everybody that participated. And certainly if you'd like to follow up, feel free to follow up with Dora or me, either one, and we'll be happy to help you out. And this is also a reminder that we have the next second Wednesday program is on June 12th with Tony Delamani discussing the FTC's ban on non-compete agreements, which is a pretty hot topic right now as well. So appreciate everyone coming today, and everybody have a great afternoon. Thank you.
Thank you.